I'm a future criminal barrister and I'm going to explain criminal appeals from the Magistrates Court. There are three separate routes of appeal. The first is appeal to the Crown Court. The first route of appeal is to the Crown Court, which is the higher of the two courts in England and Wales for criminal proceedings. As long as written notice is served within 15 business days of sentence, then everybody automatically has a right to appeal to the Crown Court. No permission is required, and this 15 days is after sentence, even if you're appealing against conviction. The appeal is a complete rehearing, so if you're appealing against conviction, it will be a retrial, and if you're appealing against sentence, it will be another sentencing hearing. The case will be reheard by either a circuit judge or a recorder, which is a part-time Crown Court judge, sitting alongside two magistrates who weren't involved in the original case. Their decision doesn't need to be unanimous and can be 2-1. However, the professional judge on the panel will make all decisions of law. The second route of appeal is to the High Court by way of case stated. This can be used after final determination of proceedings in three events. Firstly, if there's an error of law. Secondly, if there's a decision in excess of jurisdiction. Thirdly, if there's a decision so unreasonable that no bench could properly reach it. There is no rehearing for this type of appeal, and it's submissions based only. This means that the advocates will just make legal submissions. The case will be heard by a divisional court of two judges, and if they can't agree, then the appeal will be dismissed. It needs to be unanimous between them. The third route of appeal is to the High Court via judicial review. Once again, there are three different types of appeal that can be made via judicial review. Firstly, if there is an error of law. Secondly, if there's a decision in excess of jurisdiction. And thirdly, and most importantly, if there's a breach of natural justice. The meaning of natural justice has been litigated a lot, but things like this might count. Failing to give adequate time for the defendant to prepare a defence, or the prosecution failing to disclose a witness statement which would have assisted the defendant's case. As you can probably see, there is some overlap between judicial review and case stated. The court gave some guidance in the Crown and Liverpool City Magistrates 2006. If case stated can be used, then it should. Judicial review should be reserved for that breach of natural justice, which usually comes down to something factual that has happened rather than something legal. Judicial review, however, will be appropriate for cases which are in excess of jurisdiction. If there's any further appeal from the High Court via case stated or judicial review, this lies with the Supreme Court. In order to appeal to the Supreme Court, three conditions must be met. Firstly, the High Court must certify that there is a point of law of general public importance. Secondly, the High Court must certify that the case is suitable for appeal. And thirdly, the Supreme Court itself must grant permission to appeal.